Let's continue some additional points on the introduction to the revised corporation code as promised. So, these are the different types of business organizations in general. There's the sole proprietorship, partnerships, which we have thoroughly discussed during the first half of the semester, joint accounts or cuentas en participación, business trusts, joint venture, which we went over when we were discussing partnership very briefly. I think I just mentioned one sentence about that. Cooperatives, which we will discuss right after the revised corporation code, syndicates, and corporations. So when we were still under Spain, the Code of Commerce governed our laws, was a governing law. It provided for a different set of business organizations, different from the ones that you see here on the screen. So there was the Sociedad en Comandita, which is the limited partnership, Sociedad Regular Colectiva, which is the general partnership, Sociedad Anónima, which we know now as corporations, and Sociedad de Cuentas en Participación, which is joint account. So I'm just discussing these not because it will be in the test, but just as an additional knowledge, no. So when we go to business organizations, the one here that you see on screen, when we talk about sole proprietorship, which I'm very certain you all know as accounting majors, is a form of business with only one proprietary owner. It's the oldest, simplest, and most prevalent form of business enterprise. So it's neither a creature of statute nor of contract. It is really, in effect, an unorganized business owned by a person, so it has no legal personality separate from its owner. The law merely recognizes the existence of a sole proprietorship as a form of business organization conducted for profit by a single individual. In a sense that it still requires a proprietor to secure licenses and permits. So they need sole proprietors still need to register with the DTI, or the Department of Trade and Industry, as required under the business name law. And failure to register a business name prohibits the use of that name in any written or printed receipts, and you cannot use that name and display it in plain view. So once you are able to get a business name, the DTI will issue a certificate of business name, which is valid for around 5 years before you need to renew that name again. And then the proprietor will need to submit to the BIR that certificate in order for the BIR to issue another certificate called a certificate of registration. And that's the time that you can actually do business, because that would be the reckoning point as to when you will start paying taxes. Now, the reason why I'm discussing this, I'm thinking about the future already for accountants like you, who might have a client that does business as a sole proprietorship. Now, you'd be thinking, for those who have read the revised corporation code, there's already a one-person corporation. The first thing that might come to mind is, what is the difference between a sole proprietorship and an OPC, or a one-person corporation? The answer is very simple. Since a sole proprietorship is an unorganized business, there's no formality there. On the other hand, a one-person corporation is governed by a particular title in the revised corporation code, which we will discuss later. So in cases where the one-person corporation is actually not able to comply substantially with the requirements under the revised corporation code, that person will be considered a sole proprietor. What does it mean? That means that that proprietor will be liable up to the extent of his or her personal assets. Okay. So number 2, partnerships, I will not discuss that anymore. And I just want you to know that when it comes to partnerships and corporations names, it would be different, because the SEC is the one that governs partnerships and corporations. Unlike in sole proprietorships, because they are actually unorganized, they're governed by the DTI, the Department of Trade and Industry, for regulatory purposes. For partnerships and corporations, the SEC released Memorandum Circular Number 13. That was issued in 2019. It's actually the amended guidelines and procedures on the use of corporate and partnership names. So for those of you who are planning to do your internship, if you haven't done so, and later on your partners in the firm would be asking you to help organize a partnership or a corporation, you might want to look into that. Now, when we talk about joint accounts or Sociedad de Cuentas en Participación, aka it's called an accidental partnership. The reason why it's accidental is because joint accounts are usually when merchants interest themselves in the transaction of other merchants. What happens is that in a transaction, say, between merchant A and merchant B, if say for example merchant X wants to join merchant A in transacting with B, it would still be a transaction between A and B. Kumbaga parang backer lang si X. So it does not have a juridical personality. There's no business name. The ostensible partner in that case would actually be A, not A and X. So A will transact under his or her individual liability. So, and then there's the business trust, a legal relation where one person called the trustor conveys property to another called the trustee who will hold it for the benefit of another person called a beneficiary. Their rights and obligations are governed by the trust agreement that they will execute. There are a few provisions of the Civil Code on trust, and the Bangko Sentral ng Pilipinas recognizes trust businesses because usually the trustee is a bank who will hold usually property like real estate or money, and that trustee bank will be in charge with the administration, holding, and management of that fund or property. A part of business trust is actually the real estate investment trust, or what we call the REIT. So some of you might be hearing that during your internship, but this is really a stock corporation. So a real estate investment trust, even if there's the word trust in it, is not a business trust. Be careful. It's a stock corporation. So you'd be asking, why are we even calling it trust? It causes confusion. There's only one reason. It's because we are adopting the internationally accepted description of that business following global best practices. But if you're talking about an REIT, please do apply the provisions of the revised corporation code. So just be careful when it comes to that. Now, when it comes to joint ventures, it's an association of persons or companies to undertake a commercial enterprise. And we have discussed that before, where I mentioned that what will be used is actually partnership law to a certain extent. So, although the contract or agreement need not be registered with the SEC, as long as it will not formally form a partnership, there are instances that the Supreme Court actually said na since there's no particular law and a joint venture is akin to a partnership, then some cases the Supreme Court applies the law on partnership. Now, when it comes to cooperatives, although we will discuss this later on when we're done with the RCC, I just want to go over the definition very quickly. Under Section 3 of the Philippine Cooperative Code of 2008, and I will upload that when we're done with this. A cooperative is an autonomous and duly registered association of persons with a common bond of interest who have voluntarily joined together to achieve a social, economic, or cultural need. So they make equitable contributions to the capital required. They patronize their products and services, and in exchange for that, they also accept a fair share of the risks and benefits of any undertaking that the cooperative may undergo in accordance with universally accepted cooperative principles. So as accountants, accounting students, and future accountants, I understand that you would be hearing a lot of universally accepted, di ba, accounting principles, auditing principles, and tiisin nyo na lang po. So they are not primarily governed by the revised corporation code, but they are still treated as a corporate entity in a sense that they have their own acts and liabilities. And so, if I cannot stress this enough, we will discuss this more, although briefly, once we finish discussing the law on private corporations. Number 7, syndicate. So, hindi po ito yung sindikato na gangster or not the mafia that we come to know. When we talk about syndicate in the concept of a business organization, we are referring to a group of people who come together to work for a common aim. So, it's really an unincorporated business association. This usually involves insurance companies who underwrite a large risk, or banks who lend a substantial amount that they can't lend it to one person alone. So, for example, if Henry C. were to, most likely, I'm not too familiar, but probably when Henry C was putting up MOA, which is the largest mall in Asia, um, definitely the loan that probably was taken out to construct that entire compound was probably not shouldered by one bank, because it would not be a sound banking practice. So most likely in that case, banks syndicated together to lend the Henry C Group, who is in charge with the SM Holdings, to lend SM Holdings that entire amount that they would be asking for. Yeah. So the word syndication, therefore, refers to the practice of dividing investment risk between several persons. So they are not a corporate entity, because it's just, kumbaga, it is the corporation alternative, no, it is analogous to a joint account. Remember, if I mentioned earlier, a joint account is where other merchants would take interest in a transaction. So they pool together, they're not necessarily a separate entity. They did not intend to form a business relationship long term. It was just for one transaction. So corollarily, a syndicate is a group of usually banks or insurance companies that band together for one transaction. Note that there's also a homeowners association, but this is really a non-stock, non-profit organization. So, of all the things that I mentioned, the only things that would be covered from 1 to 8 under the revised corporation code would be 1, corporations under number 8, 2, the REIT, which I mentioned, and 3, homeowners association, because homeowners associations are really non-stock, non-profit organizations. It is a corporation even if it's governed by the Magna Carta for homeowners and the homeowners association, and even if it is actually regulated by the Housing and Land Use Regulatory Board. So, why is there a need for the revised corporation code? It's more number one, it's more about the ease of doing business. What do I mean by that? Number one, the name verification process is simplified. For those of you who might be running the family business, or for those who have interned for a corporation, before, if you need to incorporate, the name must not be confusingly similar. That was the requirement. Now, under the revised corporation code, the only thing that is needed is that a name must pass the distinguishability test. What does that mean? Before, under the old code, if, for example, a company called ABC Network wants to apply for a corporate name, before, the SEC would actually disapprove of the name ABC Network because there is actually an ABC restaurant already. They'd say, oh, it's confusingly similar because there are the words ABC. However, under the revised corporation code, that can actually pass because it's distinguishable. How? ABC Network is for a networking company, or say, for example, telecommunications company, whereas ABC restaurant is for the food industry. Yeah. So there, in the case now, the SEC would most likely approve of that name because it's distinguishable. Number two, ease of doing business. There is a perpetual existence. Before, under the old code, the existence of a corporation is only up to 50 years, but it can be renewed. So companies like San Miguel, which has been in existence for 130 years since 1890, both you and I have not yet been born, it would be difficult for these corporations because they need to do paperwork. Otherwise, their business would be discontinued because of this technicality. Number three, in ease of doing business, there's the OPC, or the one-person corporation. And the reason why the lawmakers included this is because they know the common practice of some people wherein they will actually just get nominal partners, excuse me, to join them, because under the old law, it is required that incorporators be at least 5. So they would usually get 4 or less na shareholders who are just nominal. They just own one share. Now, number 4, what in terms of ease of doing business, Now, stockholders may actually vote through remote communication or even in absentia. Kasi, the lawmakers recognized the the problem of paper minutes. Diba? Minutes is what happens during a meeting. Paper minutes is where it is declared that certain persons were present for a meeting just to meet quorum, excuse me, but such did not actually happen. And number 5 in ease of doing business is the electronic filing system. So, the lawmakers recognize that out of around 800,000 registered companies, only 500,000 are doing business right now. And it's because of the difficulty in filing that the SEC cannot actually monitor all the corporations if they don't come to the SEC. So now, because of the electronic filing system, it's easier. Okay. Now, number 2, corporate and stockholder protection is another reason why the corporation code was revised. Now, number 1, there is the creation of the emergency board. In cases where the board of directors are actually holding a perpetual holdover position, this is usually kasi when the board of directors term has already lapsed. So, syempre, the stockholders would need to hold a meeting to vote for the new set of boards. And usually, it's difficult to get a quorum. So what happens is that the current board holds their position under a holdover position. And it happens perpetually. So that's where most intercorporate disputes occur. Sometimes to the point that there are two boards acting. And it happens with large corporations pa. So you can imagine, it's difficult for third parties to transact because one set of parties transacts with one board and then the other with another. Tapos syempre, it will be an issue of how to claim liability against the corporation. In that case, an emergency board will be created only for a limited period and for a limited purpose to allow the corporation to continue its daily operations even if there are vacancies in the board. Number 2, under corporate and stockholder protection, now there's the revised rules on the right to inspect corporate books. Before kasi, it was required that the stockholder exercise that right by him or herself. Now, they may actually get a representative to do so because most of the stockholders are not really versed with interpreting documents, especially if that corporation is a highly specialized field that they don't know. Syempre, stockholders naman, the only thing they care about is returns, not necessarily that they're investing in a business that they know how to run. So, in this case, they would get a representative or a counsel such as you guys who are the future accountants. So they who would need to inspect the corporate books on behalf of the stockholder. Now, as future accountants, you can represent your clients, especially when they would like to audit a particular transaction or to determine the true financial position of the company they have interest in. Okay, number 3, modified quorum requirements. I will discuss that later on. Number 4, there are now expanded grounds for the disqualification of directors. Okay. What else? Strengthening corporate framework. There are 3 under that. What does it mean when you say strengthening corporate framework? Number 1, when it comes to commercial disputes, the revised corporation code now requires that corporations undergo arbitration. What is arbitration? Arbitration is a mode of settling disputes outside of court. In these cases, you cannot appeal the decision of the arbitrators to the regional trial court, the CA, or the Supreme Court, no? Unless there is evidence of corruption. There are different ways of going through arbitration. Actually, the beauty about it is it's fast and efficient. Most companies, especially first world countries or countries that are business hubs, do suggest arbitration because a corporation, say in Singapore, and a corporation in the Philippines, if they have any dispute, will submit to arbitration where Philippine corporation will select one arbitrator, Singapore corporation will select its own arbitrator, and the two will select a third independent arbitrator, depending on where they would like to hold this arbitration. So in the Philippines, there's the Philippine Dispute Resolution Corporation Incorporated, or the PDRCI, and there are a list of certified arbitrators whom you can choose from. So, for those of you who'd want to do that, it's fun. I took the test. Madali lang siya. It's easy to pass. Yeah. Number 2, there are some amendments on dissolution. And number 3, the revised corporation code actually aligned the powers of the Securities and Exchange Commission with the, because the SEC has its powers under the Securities Regulation Code. So now, in order to drive that, there was a need to revise the corporation code para it's in harmony, the SEC's powers. And lastly, when you talk about good governance, it's about instilling corporate and civic responsibility. Now, under the revised corporation code, we are now imposing stricter good governance standards. So, for example, in compliance with the United Nations Convention Against Corruption, there is now what we call a corporate criminal liability and penalties for graft and corruption. So aside from paying hefty fines, corporations now may also suffer the revocation of its registration. Under the previous corporation code kasi, if there is any criminal if there's any criminal act under the corporation code, those who are criminally liable are the responsible directors or officers of the corporation. Now, the corporation itself is held to be criminally liable. But since, of course, you cannot physically imprison a corporation, the consequence of this criminal liability are fines and or the revocation of its registration. Okay, what's another instance of good governance? For corporations vested with public interest, there is now a need to have an independent set of directors. And now there's also the requirement of having a compliance officer. So what's the purpose of this? What is the role of this compliance officer? He or she is usually in charge of making sure that the particular laws in relation to that corporation are followed. These are meaning for corporations vested with public interest, such as educational institutions, banks, insurance, transportation, telecommunications, and other publicly listed companies or other types of companies that the SEC may declare to be vested with public interest. Before we end this slide, for those of you who might want to write down what are the acts that a corporation may be held criminally liable, they are those under Section 17, 161, 165 to 167, and 171 of the Revised Corporation Code. To be clear, these are the only acts where a corporation may be held criminally liable. Meaning, the corporation is not criminally liable under the Revised Penal Code, which is a different law pa. I just want you to know that because for those of you who plan to be lawyers in the future, when you talk about the Revised Penal Code, meaning the criminal acts that you know, like murder, rape, or whatever, these are acts that what we call mala in se, meaning intent is necessary. It must be proven that that person intended to commit the crime. Whereas in special laws, such as the Revised Corporation Code, intent is not necessary. As long as you violated it, then you are criminally liable. Which is bagay, or it's just right for corporations because corporations don't have intentions, diba? It only acts through its board. Okay. Now, I mentioned in the first video that Attorney Laco mentioned GOCCs or government-owned and controlled corporations as public corporations. Now, there's a book, Aquino and Aquino, that says the Constitution provides that only GOCCs are the only private corporations that may be created by special law. Okay. For those of you who have a book, although I don't require it, 4 of the books that I am reading, and yes, I'm reading 4 to 7 books, mentioned unanimously that GOCCs are are public corporate, kill me now, sorry. GOCCs are private corporations. So they fall, four of the books that I'm reading, Soriano included, and De Leon, all agree with Aquino and Aquino that GOCCs are actually private corporations. They say the only public corporation are what we call local governments, like the municipio, barangay, there. However, the Supreme Court actually created instances where they categorically stated that GOCCs and other corporations like the Boy Scouts of the Philippines, as a landmark case, is a public corporation. So now you'd be confused. Now, for all three Act Reg 1 classes, C31, C32, and C33, if I'm not mistaken, just to be clear, let us now treat a GOCC as a public corporation. Why? Because there are GOCCs that are considered public corporations because they carry a public purpose. Okay? So if a GOCC was created to execute proprietary functions, then it's considered a private corporation. Now, I consulted actually with a corporation code expert, wife of my former boss, Dean Cynthia Del Castillo. I asked for clarification regarding public and private corporations. And I mentioned that I read some books that stated that only local governments are public corporations. And this is what she said, no? There are different kinds of classifications. One based on ownership, which makes the GOCC public because it's owned by government. Another classification is the based of manner of creation. Meaning if it's organized through legislation or what we call a special charter, they are public corporations. While those registered under the Revised Corporation Code are private corporations under the jurisdiction of the Securities and Exchange Commission. And there's also a classification based on whether you are required to register your shares under the Securities Regulations Code and are called public corporations. So these are, if I remember correctly, we will discuss this later on, public corporations under the SEC are those with 50 million pesos in capital with 200 in shares, 200 shareholders wherein at least 100 own 100 shares, something like that. So let me just discuss that when we get to that topic, no? Yan. So in that case, they're also called public corporations. Therefore, after everything that I've said, for uniformity purposes, public corporations are the local governments and GOCCs, okay? Unless they are executing proprietary functions and were registered or incorporated under the Revised Corporation Code. So local water districts are considered government-owned and controlled corporations with special charters, since they are created pursuant to PD 198 or the Provincial Water Utilities Act of 1973. Okay. Last slide. What are some points of clarification that I will go over as quickly as I can? I've already discussed separate juridical personality. Let me just make it clear that there is still a juridical personality, one juridical personality, even if the corporation maintains different places of business, like a branch. Okay, so a Corporation A with branches in Manila and Bulacan will have one, Hindi separate ang juridical personality sa Manila branch, sa Bulacan branch, and whatnot. Number 2, limited liability when it comes to a one-person corporation. Sorry. Let me go back to the separate juridical personality. It is clear that the shareholders' pieces of property are separate from that of the corporation. Therefore, the insolvency of a corporation does not prohibit a stockholder from transferring his personal property or even his shares in the corporation. Because the interest of the shareholder in the corporation is different pa ha. Let me make it clear that the interest of a shareholder in the property of the corporation is indirect, contingent, and inchoate. When does a shareholder have actual, direct, and existing interest over the corporation's property? Only when the assets have been liquidated and assigned to that particular shareholder. And there can be a trick question made in relation to that concept. So just please be careful and understand that concept. Okay. Any damages claimed by a corporation, say a corporation was mismanaged, and its assets were also mismanaged or misused, the stockholders cannot claim damages on behalf of the corporation. Otherwise, that would result in the appropriation or distribution of corporate assets to the stockholders who brought suit, even before there is a proper dissolution. So the obligations incurred by its officers or agents are the direct accountabilities of the corporation they represent. So what happens in case of mismanagement? Then there must be a board resolution on who to file. What if it were the board who mismanages it themselves? Then that's the time that there's actually a provision under the Revised Corporation Code, and we will discuss that as to the remedies that the stockholders may take. But those are actually unique instances ha. Regular damages case by a corporation, ang general rule is that it must be the board that will authorize a representative to file a case on behalf of the corporation. It cannot be that the stockholders will go directly to court and say, oh, we're doing this on behalf of the corporation. So there's an exception as to when the corporation is not directly liable for the acts of its directors, officers, or agents. And those are discussed under Section 30 of the Revised Corporation Code. Section 30 discusses the liability of directors, officers, and trustees. And we'll get there when we formally discuss that topic already. I just want to discuss very briefly a case that I found very interesting. This is the case of Bautista versus Autoplus Traders. Now in this case, Bautista is actually a president of another bus company called the Cruiser Bus Lines. Cruiser Bus Lines issued a check to Autoplus Traders, 2 checks, and those 2 checks bounced. So what Autoplus Traders did was it filed a criminal case against Bautista because he's the one who signed the check. Now, that criminal case, he was actually acquitted because there was no proof beyond reasonable doubt. No, I just wanted to discuss the civil aspect. In that case, the RTC modified the decision. The RTC said, Bautista, you pay Autoplus. And the Supreme Court corrected that. Bautista is not personally liable for the company's checks. The Supreme Court made that clear. It's actually Cruiser Bus Lines who should have filed a case. It should be Cruiser Bus Lines whom Autoplus Traders should have filed a case against. Kasi it was Cruiser Bus Lines check. Yeah. Okay. Now let's move to the limited liability when it comes to a one-person corporation. For a limited liability of a one-person corporation to apply, the Revised Corporation Code imposes upon the shareholder the burden of proving that the corporation was adequately financed. If that shareholder, that one person was not able to prove that his or her corporation was adequately financed, then that shareholder will become jointly and severally liable. In effect, that shareholder will become a sole proprietor. Why is it that they need but to prove? Because financial inadequacy of a one-person corporation is actually an indicator that that OPC is being treated as a conduit of the shareholders. So if you remember my extremely long discussion about alter egos, yan, dun siya papasok. Okay, now let's go back to piercing the veil of corporate fiction as if I've never discussed that enough earlier. When we, in cases where we pierce the veil of corporate fiction, please take note that the corporation's personality is not abrogated. What do I mean? It means that the corporation's separate character continues for legitimate objectives. The courts and the administrative tribunals like the National Labor Relations Commissions are the only ones who can disregard or can pierce the veil of juridical personality for a particular transaction that is under dispute in court. It does, meaning once a court says, okay, we're piercing the veil of ABC Corporation, it does not mean that all transactions entered by ABC will be affected. Meaning, kunwari, when we're talking about a sale of property between X, a person, and ABC Corporation, and the court says, okay, for this sale of lot, we are allowing that ABC Corporation was just used as a veil by A, B, and C. So X can now run after A, B, and C because it was only an alter ego. It does not mean that other transactions of ABC, say for the purchase of supplies, can also be charged against the personal assets of ABC. Kasi we are only talking about that sale of property between X and ABC. Okay. Okay, careful. Point number 4. Public company versus a public corporation. There is a difference. A public company, actually, you remember if I just mentioned earlier about Dean Cynthia, when she mentioned a public corporation, actually, it's actually a public company under the Securities Regulations Code. Public companies are corporations with a class of equity shares listed on an exchange like the Philippine Stock Exchange, or with assets in excess of 50 million pesos and having 200 or more stockholders, at least 200 of which are holding at least 100 shares of a class of its equities. So, that's actually a public company. Public corporations, as if you're being extremely strict about it, I maintain, are really just municipalities and barangays, or what we call municipal corporations. So, for those of you who are worried if ever that comes up in the test or in the quiz, let us handle it. We'll take care of it, okay? Hi. Government instrumentalities are not public corporations. So, just that's self-explanatory. I don't need to discuss that anymore. Yan. Oh, okay. For those of you who are not familiar, what are government instrumentalities? Later on, probably when in your internship or when you start working or doing your own business, you will come across these. These are called GICPs. Actually, some of them. GICPs are government instrumentalities with corporate powers. They are not corporations, even if they're called GICPs. And neither are they government agencies. They're only vested by law with special functions. So what do I mean when I say GICPs? These are the Manila International Airport Authority, or the MIAA, the Philippine Ports Authority, Philippine Deposit Insurance Corporation, the MWSS, or the Metropolitan Waterworks and Sewerage System, LLDA, PFDA, the Philippine Fisheries Development Act. You don't need to memorize this. I'm just mentioning it. Basis Conversion Development Act, that's government instrumentality. Cebu Port Authority, Cagayan de Oro Port Authority, what else? San Fernando Port Authority, Local Water Utilities Administration, the LWA, not the corporations under the LWUA's jurisdiction. Okay, if you guys are starting to nosebleed, please message me. I can hear the person beside me here na medyo nag-gloss over na his head. The Asian Productivity Organization. Yan. But, to add further confusion, and don't hate me, the GOCC, the Government's Act of Good Governance Act of 2001 actually classifies GICPs, or government instrumentalities with corporate powers, as GOCCs. So for purposes of this class, government instrumentalities are not corporations. Medyo, there are times lang kasi the lawmakers create a law that will create some confusion, and sadly there are some instances that a Supreme Court ruling might actually further lead confusion, so bear with us. We will try to harmonize them as much as we can. Okay. Next, interest-bearing stocks. Is there a thing as interest-bearing stocks? Yes. These are instances, usually preferred stocks, where the corporation agrees to pay interest before dividends are paid to common stockholders. So, this is only legal when it is construed as requiring the payment of interest as dividends from net earnings. It is not parang if a year goes by, regardless of whether there are dividends declared, the corporation must pay interest. No. It may be called interest loosely, but when you say interest, it's still out of the unrestricted retained earnings, much like any dividend declaration. Yeah, bakit? Because if you remember what I mentioned in the previous video, payment of dividends to a stockholder is not a matter of right. It's actually a matter of consensus, meaning the board must agree that, okay, out of our unrestricted retained earnings, we will distribute some as dividends. So it's a matter of consensus. Dividend rates. Can dividend rates change? Meaning the rates on the preferred stocks usually, no? Yes. Since the board of directors has the discretion to determine whether or not to declare dividends, then it shouldn't be prohibited also to change dividend rates. As long as such authority is stated in the Articles of Incorporation. But be very careful. The SEC, the Securities and Exchange Commission, already gave an opinion. Although the board of directors may fix the terms and conditions, usually of preferred shares like dividend rates, no, they are not given blanket authority because it might lead to abuse of authority. So a stipulation in the Articles of Incorporation that state na preferred shares shall be entitled to dividends in such rates as may be determined by the board, that's actually not allowed. It's actually considered an invalid provision because there are no guidelines. So what are some features that the Securities and Exchange Commission looks for in order for the board of directors to change the terms and conditions like dividend rates? Usually, these are cases, for example, preferred shares are redeemable within 1 to 10 years from date of issue, as the board may fix that they shall earn cumulative dividend of 6 to 16% per annum. So may guidelines, may range, as the board may determine. Yan. Pwede yun. Okay. One more thing to be clear. If preferred shares are non-cumulative, I don't remember if I mentioned this earlier, then it means that the dividends declared are paid out of earnings for that particular year only. Yan. So, because we like to borrow quotes from Supreme Court Justices of the U.S., no? Justice Oliver Wendell Holmes declared that dividends that were passed are forever gone insofar as non-cumulative preferred shares are concerned. Galing, no? Ginawa pang literary piece. Yeah. So, common shares, voting rights. Common shares cannot be deprived of the right to vote in any corporate meeting. So, that's what it meant in the previous video when we discussed the provision that states that there shall always be a share of stock that has complete voting rights. So again, common shares cannot be deprived of the right to vote in any corporate meeting. There's another opinion by the SEC. A stipulation in the articles that the voting rights of a class of common shares shall be assigned to a trustee who shall exercise all the rights for all corporate actions may actually be construed as a denial of voting rights. So parang you're requiring a common shareholder na before you purchase common shares, you must assign it to one person. Hindi parang you already deprived that common shareholder of the right to vote. Okay. This is actually self-explanatory. Escrow and treasury shares are not reflected in the Articles of Incorporation, and I just want to explain. It's because they are not initially issued as escrow or treasury shares. They were first issued as either common, preferred shares, or redeemable shares, diba? They merely become treasury or escrow shares by virtue of a subsequent transaction after its issuance. So although it's self-explanatory, I felt the need to just highlight that. And last, redeemable shares. Redeemable shares may be likened to temporary borrowings to enable a corporation to adjust its corporate structure. So they facilitate the corporation in raising badly needed capital, but at the same time, not deceive creditors. Meaning, having redeemable shares places notice to the world that they are dealing with a corporation whose funds are partly committed for the payment of redeemable shares. The only condition, kasi diba, if you remember our previous discussion, redeemable shares may be redeemed even without unrestricted retained earnings because it was clearly provided under Section 8, if I'm not mistaken. The only condition is that after redemption, the assets of the corporation can still cover debts and liabilities. When I say debts and liabilities, that includes capital stock. That's why mandatory redeemable shares, as I mentioned before, are usually paid using a sinking fund, which I'm sure you're familiar with from your basic accounting. Note that for tax purposes, when redemption is considered a scheme to circumvent paying taxes on cash dividends, it can actually still be declared as cash dividends. But that's for tax purposes na. I will not go too much into length because that might be discussed by, if I'm not mistaken, Sir Ace Escartin. Yeah. So that ends our continuation in the introduction. My apologies if it's too long. I will make sure that the subsequent videos for titles 2 to 18 will be straight to the point and short. Kasi I'm sure magno-nosebleed kayo guys because there's a lot of requirements. Pero kaya nyo yan, madali lang yan. So, good luck!